Hi, welcome. Thank you for joining us for this short webinar on the law of unfair dismissal, and in particular, the law of redundancy. And what is a redundancy is the question we're asking today. My name is Gary Smith. I'm one of the partners in the employment team at Knockhold's Solicitors. And the question then, what is a redundancy? Well, a redundancy arises in one of three circumstances. So firstly, the business closes down. Secondly, the place of work closes down, albeit the business carries on trading elsewhere. And then finally, the business requires fewer employees to do work of a particular kind. And in today's session, we'll spend just a couple of minutes looking at each of these in turn. So firstly, a business closure. Well, it can be either a temporary or a permanent closure. It could give rise to a redundancy. Obviously, a permanent closure is normally pretty final. The business no longer exists. You can no longer be employed by that business. It is inevitably going to be a redundancy. But where there is a temporary closure, whether that closure is significant enough to trigger a redundancy scenario will depend on the facts. Now, if the closure is maybe only for a week or so, then it may not do. If you start getting beyond a month, it is more likely that a redundancy will have been triggered. You do then have this additional question as to whether as to what has happened to the business, because if the business has transferred elsewhere, then do the TUPE regulations apply to take the employees with the business, or has the business simply ceased and no one is servicing the customers, the clients, etc. So then a workplace closure. So this would be the individual's office or factory or warehouse, but the business carries on trading elsewhere. And what is the employee's workplace is a factual question. That you can have situations where people work in multiple different places, but if for most people, they will have one core location where they undertake most of that work. If that location were to close, then that would create a redundancy scenario. Again, the closure can be temporary or it could be permanent. The question then arises as to whether there is a mobility clause in the employment contract, something that says something along the lines of you will be employed to undertake your role at our offices at X or such other place as we may reasonably require in a, say, 20-mile radius of our offices. If you have that sort of a clause, it doesn't change the fact that a redundancy situation exists, but it does allow you to assert that the move within that 20-mile radius is a reasonable alternative proposal, such that the entitlement to redundancy pay is lost if the employee unreasonably refuses. You do, though, have to enforce mobility clauses reasonably, and you should maybe take some advice on that before enforcing it. The third scenario then, so fewer employees required to do work of a particular kind. There is often the feeling that this relates only to a downturn in work, but actually that is not necessarily the case. So you can have situations where work has stayed at the same amount or has in fact increased, but fewer employees are needed to do that work. Maybe you've automated, maybe you've put something, running a process digitally when it was previously done manually, that sort of scenario. You then have the usual scenario, there is simply less work, so you require fewer employees to do it. Or it could be that there's less work, but you need the same number of employees, but in different roles, and you need to reallocate people or make some people redundant and recruit some into those roles you need. The alternative there is that work is being done in another location. So a similar scenario to the closure of the workplace, but maybe the workplace is still continuing. You've just moved a team or a department, and so that can create a redundancy as well. The good thing from an employer's perspective is that your staffing levels and the number of staff you require is for you to assess. Okay, as long as you go from 10 staff to 8 staff or 6 staff to 4 staff, etc., no employment tribunal is going to question the business rationale and common sense behind that decision. That is for you to decide as the employer. So that's all. I hope you found that useful. The next in this series of 5 webinars will be on consultation process and what you need to do to fairly consult. Hopefully you can join us. Thank you.